That'd be my pleasure.
I think in this one, if I might, number 1, it said quorum or members. I think it should say quorum of members. So with your permission, I'll make that change before first reading.
Oh, there it is. Before we go any further, I think maybe we'll just, I'll wait till Helen sits down. I was just going to open it up for public comment on all of the agenda, on all of the amendments, other than go one by one, if everyone's okay.
I think that's gonna be kind of hard to do. I mean, they're gonna be talking on the 8th one, you know, right now.
We can just turn to the 8th page and go for it.
With this few people in here, I would just say go as we go.
Okay, that's fine.
Okay.
Here.
Let's do, yeah,
Okay,
If the room fills up, then we'll change it.
okay.
one at a time.
All right, then the first one is the simple majority vote. Any discussion here?
I think what we did last time is decide whether you wanted to put it on the ballot or not in March or November. Some came off, some said we'll consider it again for March. So as we're going through this, if you don't want to see something for first reading, I guess we could take it off, or you could wait till first reading to do that too, if you'd like to.
I would like to hear from the
Charter committee?
charter committee, the reasoning behind some of these, and this is one of them. If you would like to do that.
They're looking at me. I think that this is one where currently you have to have an affirmative vote of 3 members. And so if there is a quorum of 3, that would require a unanimous vote. Or if for some reason 2 commissioners out of 5 have a conflict and can't vote on something, you would have to have a unanimous 3-person vote. This would change it just to be if any item came in front of the commission, it would be a simple majority of the quorum. So if it's 3, it would be 2. If there's 5, there would be 3.
So you're requiring.
If there's 4, you would be deadlocked at 2, and it wouldn't pass.
No, you're saying if there's 3, we could have a 2 vote?
2 to 1 would pass then. Where under the current charter, a 2 to 1 vote would not pass.
That doesn't seem like it's
Yeah, I disagree with that.
big enough poll. I know.
What,
Yeah, you have to speak in the microphone, yeah.
can Doreen go over here like she did for the other one that we did?
Oh, that's fine
Since
too.
it's a workshop?
As long as
Whatever
she's on
the
a
pleasure of the
microphone.
board is.
It's our pleasure.
They said that's the most important thing a city manager can say.
Now we can't see her. She went down too low.
Well, my legs aren't long enough to reach the floor anyway. So, all right, so the point there is that we haven't really, I don't think, as the city, been following exactly the way it should be. In the sense that by reducing the numbers, as he said, it makes it more cohesive so that you don't end up with 4 people and having a tie vote and not being able to move forward with the vote. Ralph, am I following that?
Well, it's if you have a quorum of 3, I think is the best example. If there's 3 people here, you would need to have a unanimous vote of all 3 to pass something under the current charter. If this amendment were to pass, an item could pass, whether it's a contract, an ordinance, a resolution, an official action could pass 2 to 1. You wouldn't need that 3rd vote.
I think it's difficult to require a unanimous 3 vote if there's only 3 of you in attendance. And it doesn't, I don't recall it actually happening, but that was the whole purpose of looking at the charter, word for word, section by section. And it was creating a situation that you could be requiring a unanimous vote when that isn't what you would necessarily want to do.
Well, there was a time recently when we only had 3 people who were going to be attending the meeting. So we decided the best thing to do would be to postpone the meeting.
And that's an option too. I think, Helen, you brought that up. But
So that is
The way it was written is,
that's only when it's a quorum, right? So if there's 4 commissioners on the board and it's voted like 3-1, it would be okay.
That would pass under
It's only
the,
for a quorum, when
That
there's
would-
only 3.
if there's 4 there and it's 3-1, it would pass under the existing charter and it would also pass under the new charter. It wouldn't make any difference.
Okay, so basically what I'm saying, it's only applies if there's a quorum, and that's it.
It only applies if there's 3 instead of 4 or 5.
it's the 3 that
A quorum
throws
is
it
3
off.
or more, yeah.
Okay, I have a question though, and I think it's for the city manager, but did I hear you correct, Mayor, when you said that one time there was only 3 people here and you canceled the meeting? Is that proper to do that if it's a regularly scheduled meeting?
That's when you were gone.
One of the concerns that we
Yeah.
had with respect to that is that per the charter, everything would require 3 affirmative votes to pass. So every item on that agenda would have to be a unanimous vote of the 3 that are present. Because of the nature of the items that were on the agenda, and they were items that were, for all intent and purpose, I think, public policy intensive, we thought it was better to have the full balance of the board discuss those items, because if we have a situation whereby it's not a unanimous vote of the 3 council members or board commissioners present, then that item can only come back by someone on the prevailing side, bringing that item back before the board. And so that would provide more of a delay, and we thought it would have some adverse impact on some of the items that were on the agenda. So instead of risk it, staff just preferred to postpone it until you returned.
Yeah, okay. I didn't know, I just didn't understand. I agree with the thinking behind it. I just didn't know if if you're supposed to do it that way.
Yeah, had this provision been in place, certainly that would have been something that staff would have recommended moving forward with the item, but with the unknown of how certain items would have been voted on, we decided to just err on the side of caution.
Because I agree with the wording on the simple majority vote. I like the way it's concise and it spells it out, and it does say if there's 3, that you don't have to have you've got the simple majority.
Personally, I still think if it's 2 people out of 5, that's not really the voice of the commission.
Right, I agree.
You're right about that, but it is the voice of the
Oh,
quorum.
but it's actually 3 out of 5, because you're not going to have a meeting if there's only 2.
If there's 3 people, 2
But
would
if you-
vote yes and 1 vote no.
Yeah, if it's a
and-
2-1
But that's
vote.
still rendering three commissioners' opinions.
Yeah,
Right.
but 2 of them could pass it, is what she's saying.
Right.
Versus having 3 being able to pass it. She feels that, only 2 doesn't really speak for the majority of the districts.
Okay, so in lieu of what the committee recommended, then there potentially would need to be possibly another legal angle of, would you want to be put into a position, you don't have an option. Your only option is to have somebody make a motion to, or the mayor make the motion to postpone the meeting as you did previously. If you don't have, if you don't have the full quorum, if you don't have more people there, then there maybe needs to be some other wording, I don't know, but,
Well, and it's not like this happens that often.
well, maybe we're too far down in the weeds. I'm just saying that the only option you have then is if you're not comfortable with having 3 present, which constitutes a quorum, then you would have to postpone the meeting.
Or Madam Mayor, or you would have to get, the 3 votes of the board being there. So it is whatever the pleasure of the board is, but from staff standpoint, we can go either way. The only issue that I could see is if there is a time-sensitive related issue, but in most situations, in my tenure here, we've postponed a meeting maybe a couple of days. It's not been something where we can't convene the board within, 2 or 3 days of that scheduled meeting date. So, that's something that's, we haven't experienced as a board.
If you like it the way it is, you would just simply reject the committee's recommendation and stay with the existing charter.
Okay. Well, I'll open this up to public comment
And we're
now.
not taking any votes formally tonight, first reading or second reading, but if you wanted to narrow the ones that are being brought to you on first reading, we could narrow here, or we could narrow at first reading.
Is it working? 13319 Boca Ciega Avenue here in Madeira Beach. I agree with Mayor Black and Commissioner Oakley. As a citizen, I would rather have an occasional canceled or postponed meeting than have two commissioners passing an ordinance or making policy.
Public comments closed. All right, well, do we have a consensus to go forward?
Yes,
Wait a minute, what do you mean?
I say yes.
You mean yes to this?
Yes to this.
Yes, you want this on the ballot.
Right. Because I think whoever the commission is going to make the decision whether they want to cancel a meeting or not, and obviously, we did, so that's the way we roll. Unless you want to put that in there, state that in there.
I think it's fine the way it is, so I don't think it needs to go forward.
So we ought to know what a yes.
Put it on the ballot, yes.
I think that the issue there is, though, that if there kind of needs to be a consensus amongst the commission.
Right.
Because otherwise, then we're having to explain the two options without really having a consensus of the commission.
Madam Mayor, if I may ask the city attorney a question. Can the Board of Commissioners adopt as part of their legislative policy manual at the beginning of the year, policy that states that that we do, of course, the charter, if amended, has the opportunity whereby we could have a meeting, but it is the board's position that they do not wish to have any item that is, if it's a, budget-related item or an item that is has some sensitivity towards it, that they don't need to proceed or recommend that the city manager remove that item off the agenda. Because there may be a situation whereby it's just a ceremonial meeting or certain elements, but can there be something in their policy guidelines that speaks to the concerns that the mayor has?
Yeah, you could put it in there if you wanted to.
So you would effectively have the flexibility to do both in the event that it was just a ceremonial meeting and, we're recognizing the Little League group, we can have 3 here or what have you, or something like that. Or if you wanted to take official action on something simplistic, maybe it's, a second reading of the budget ordinance or something like that, that's time sensitive. You do have the flexibility, but you can state in your policy that you would prefer that, items that are, sensitive in nature or have, major implications if passed or discussed be postponed, and we can work on, obviously, the wording. So.
It's a pretty good trade-off.
I still think, I just don't like the idea of two people being able to pass something.
But if we put it in the
Board of Commissioners handbook.
that says, if there is just a quorum of 3, to postpone any sensitive issues that come across the board, so it's not.
Or, right. And you can make it to where it can be, items that are routine city business, like items that are considered ceremonial or consent. Any other item as it relates to approval of contract, resolution, or ordinance would be prohibited from, coming forward at that meeting. So you can really, pin down what can be discussed, and it's totally the board's decision, but it effectively gives you the flexibility if you wanted to.
So you wouldn't be postponing the whole meeting just because of a quorum of 3. You could postpone a particular item. You could remove it from the agenda, correct?
Right.
And let the meeting continue based on the fact that it's a general housekeeping type meeting without having any major impact. And then if
But
it
we can
is
do
something
that
that's
anyway.
sensitive.
I mean, we don't have to have legislation to tell us that. We can just do it as a matter of course.
I just personally didn't like the idea that it required, if you did, the way it's worded, that requiring that if you did have the 3 people, that they all have to have a unanimous decision. That, to me, doesn't seem particularly democratic. So,
I say we kind of put it out there to the voters like it is, just change the word of, or to of, and I guess the only one that really bothered me in there was the word ordinance. But ordinance has got to be read twice anyway, so the second one, it could always be voted down, even though it was voted up on the first one.
That's true.
All right, well, as far as I can look at it, I still don't think it needs to go forward. So we've got 2 for yes and 1 for no, and comes down to you 2.
Oh, I said yes.
Okay, just wanted to.
Just leave it in.
Okay, well, then that will go forward.
I'm sorry, I couldn't hear what you were saying.
That, it will go forward.
Okay.
We just need to change that word.
Just change the word.
Yes.
Which word? Oh, the one I talked about?
Yeah,
The
or
vote?
to of,
Of a quorum, okay.
yeah, instead of or,
And I'll use commissioners instead of members.
okay.
Sure, go ahead.
On Boca Ciega Avenue here in Madeira Beach. I don't know how you get around the first 5 or 6 words, unless otherwise expressly provided by this charter, comma. To me, when I read that, I don't think you can just take your commissioner handbook and change things. Because I would think our charter trumps the commissioner handbook. So I think this has to be rewritten some way.
Okay. Thanks for the
So if an
input.
item was put on an agenda, you would have to meet the charter, but there's nothing in the charter that requires items to be put on an agenda. That would be like a scheduling thing that's in the handbook that the city manager is talking about.
And that effectively would govern, that resolution that adopts the manual would govern how the manager would put the item on the agenda. So it doesn't preclude the board from doing items, because obviously the charter trumps it, but from the staff standpoint, it sets a clear delineation as to what we can and can't do, and of course, we're gonna adhere to that, because that would be a violation of the resolution that the board has proffered in your manual. So it really helps, it really allows for staff not to move things forward that's inconsistent with what the board's legislative intent is.
Next, we have ballot question number 2, term limits, which discusses whether or not we will establish term limits. How does everyone feel about that one? I think it's a great idea.
I think instead of 2 years, like it says in there, I think it should be 2 terms.
Why? Just curious.
Just so you get away from it for a while, get a fresh look, and then you come back. I think just being out 1 term, I don't think you really do 2 years. Being out 2 years, I don't think you really do. I'm a strong believer in term limits anyway. I'm a very strong believer in term limits, you know. So that's why I think if you just put out for 1 year and you're right back in, I don't really see that as being effective for term limits, in my opinion.
Well, 2 years does constitute 1 term, though.
I know, but I think it should be 2 terms.
So that'd be 4
Oh,
years.
Okay, I don't. I like the 3 consecutive regular terms, okay, 6 years to be in. And I think that stepping down for a 1 term still keeps you on the beat with what's going on, if you're interested enough, and allows you the opportunity to rerun after that, after that single 2 years or 1 term out.
Yeah,
Keeps you
that's
still into it.
I think 2 years is reasonable.
Yours is gonna be 3. Mayor did 3.
Right.
Okay.
Mayor's 3 years, yeah.
Do-
but-
Does that need to be specified in there?
It
No,
probably
because
should.
she can
No,
step
'cause it
down after
says
two,
either.
and be out for 2 years and go for a commission seat.
Well, that would be a different seat, so.
But still,
It's not a
That's not,
term.
Well,
that's
no,
not
it's not a-
consecutive and in the same seat.
Why can't it be 2 years for everyone?
That's
Just
the way
because I
it's
served
written.
3, doesn't, I don't know
Three
if that
years.
matters.
yeah,
That's fine.
says read the mayor district. Okay.
So how are you changing it, or what do you? The mayor has a 3-year term, one term is 3 years.
Floor is now
If-
open for public comment.
Wait, she was talking.
Okay.
Oh, I'm sorry.
I'm sorry, no, I just need to understand, it's
Should
still.
that say 2 years or
It's
one
just like
term?
it says. Yeah, I agree with it, just like it says.
If you change it to what Helen or what John was suggesting, and you substitute the word term instead of, for example, the 2 years
2 years.
is listed, then you get into the mayor's term being 3 years and the commission terms being 2 years. And I think it was the intention of the committee that it set that aside, either, because it says very clearly, either mayor or district commissioner, and it's specifying a 2-year period. So if you change it to term, then you're back to having to juggle between the two.
Did you wish to speak?
Promises.
I agree with term limits too. I think that's a great idea. The only issue I see with this is right now, I just want to be clear that this kind of resets the clock on the terms everybody has right now, because if we apply this retroactively, it only affects one person, one commissioner on the board, and that's Nancy Hodges. She's the only one at risk now and cannot run for her seat in, I don't know what year you're up, 2020 or something? Everybody else here gets to continue on. So what I would ask is that, I don't mind this. I think it's a great idea. Mix it around, let other people have a chance to govern and help out the city. But I think what we need to do is reset that clock for everyone who's on it and say, this is term 1 for everybody across the board. Treat everybody equally. Because I know everybody else on this board, it's their first term, except for Nancy. And it's kind of no secret that she's a minority, in the minority of this group. So I don't think that was the intention, to try to push her out, but that was, cynical people like me think like that. So I would hope that it wouldn't apply retroactively, that's all.
But you're saying, but it would count the term that we're sitting in right now?
Like, this would be term 1 for everybody, and then everyone could do 3 or 2 more terms, even if it involves Nancy. I don't know what term you're on, but even if you're on 4 already. So it would reset everybody to this is their first term, and then she would get 2 more chances, just like everybody else on the commission.
Seems fair.
I'd like to ask the chair, Doreen, did y'all discuss that? Was that part of your
I
deliberations?
don't believe we did, no. There wasn't any discussion about resetting or retroactive or any of those in the discussions.
Okay, what's your thinking on it, though, the retroactive? I think I certainly wouldn't go back. I mean, I think that the term that we're sitting in now should be clarified as the first one, but I didn't know what.
Hadn't really thought
That would
about
be
it
only
again, because
fair.
we hadn't
Okay.
discussed it, but I don't see a particular problem.
Okay, I guess the reason I thought it would be the first one is because when it passes, there's no indication, there's no wording in here that talks that it's going to be retroactive.
Right.
back.
The attorney talked to it
Yeah.
at
okay.
one point. Wow. Didn't you talk to this at one point?
I was just drafting some language, I guess if you wanted to say, beginning on March 12th or March 13th, the day after the election, you could put that in the beginning of the sentence. That would start the term limits clearly and expressly. It would set date in there, beginning on March 13th, 2018. The mayor and district commissioners shall serve no more than 3 consecutive elected terms.
So that would technically put everybody back as the election in March is going to start as first term.
So if
So
you're,
your next election is gonna become your first term.
Right.
Because otherwise, you're gonna be making it retroactive to some point for us. You know, if that's the point, is to not make it retroactive to anything.
I think there was a case, and I can go and look it up between now and first reading. It was either in Palm Beach or Lee County about whether it was retroactive. And I think in that case, there was no express language, so it was a close call for the courts. If you want to decide and make it expressly in here, that's what we should do. You should decide and then write in what you want it to be.
So
there's no
simply starting at
ambiguity.
March 13th, 2019 sets the stage and goes forward.
So that just starts everybody over at ground zero at that point.
Sure.
Yeah.
That seems the only fair way to do it, because, I mean, you can't say that, John, who is in his second year, is any different than Nancy, who's in her 8th year. I mean, you have to have a starting point and make that across the board.
But I think you also run into the point, because the mayor being on a 3-year term, it gets kind of confusing in there. Somehow, because if we make it March, you've already been in for a year.
It's not a reelection. for
Yeah, but her
Mark
term,
Merritt's
her term
seat.
wouldn't start till her next election.
You could say beginning on March 13th, 2018, any seated
Nine.
mayor,
19.
or 2019.
Okay.
Any seated mayor or district commissioner shall serve no more than 3 consecutive elected terms of office. I think that would do it. I'll have to think some more about it, but I think that would.
That sounds logical. Yeah, beginning, okay.
Linda Hine, 401 150th Avenue. Listen to that discussion. I think that's the right way to go. You have to have it when it starts, and you can't have it appear like you're trying to chase Nancy Hodges out. That would just make division and everything else. So everybody just starts their first term the day after the election and then follows those term limits. I think it's the fairest, and you can't complain about that.
Right.
So. The end.
Public comment is now closed, and I think we have a consensus to go forward. Next, we have ballot question number 3, forfeiture of office for knowing violations. I guess this says if you knowingly violate versus inadvertently. How do you define knowingly and inadvertently? How do you know if someone knew something?
Yeah, see, I don't like that word in there, knowingly. How do you ever prove somebody knowingly violated?
Right.
And you say, oh, I didn't know, oh, I didn't know.
Yeah.
I don't like that word in there at all. And I think that's just very poor wording, because then it would be upon the commission to prove that person X knowingly violated something.
Okay, well, one thing is that this ballot question 3, as discussed on Monday night, ballot question 3 and ballot question 5, isn't that right, Chair? Went hand in hand, so you really kind of have to look at, I think, both of them, I guess, at the same time to really understand where that knowingly comes in.
Do you want to let Linda comment since she's...
Linda Hine, 401 150th Avenue. I was just going to say, in order to have it decided there was a violation, it usually goes to court, and the court will say it's knowingly or willfully. Maybe they say willfully. And if they find there's two ways they do it. I'm not a lawyer, but, it'll be clearly they meant to do it, and here's a big fine for them, or they didn't mean to do it. But it happened. It's still a violation. So I'm sure that confused more. Never mind.
But I think that ties to what John was saying, and I think you answered it. In other words, the commission is not determining that there was a sunshine law violation or an ethics law violation or a public records law violation. It would have gone through the proper channels. Someone would have filed a complaint. And that complaint goes through the process of the Sunshine Law, the Ethics Committee, or Public Records Law, and that determination is the ruling that what the committee was trying to say was that a commissioner forfeits their office for having been found guilty of these particular law violations, that they would forfeit their office, that they shouldn't be serving. But by the same token, if it was a trivial, I didn't realize that I was violating it, public records law, somebody requested something and you accidentally deleted it, which was an inadvertent, you could still be found guilty of it, but it was so minor. It's like the difference between a misdemeanor and a serious crime. And that was where we tried to find a word that would say that what's the difference between a very minor infraction, maybe that's the word I'm trying to say, infraction, versus someone who really broke the law and was found by these various committees and commissions to have, you're not making the judgment.
Right.
You know,
So it came up, I can explain a little bit more too. Right now in the existing charter, it lists the grounds for forfeiture of office, and it says, is convicted of a felony or a misdemeanor involving moral turpitude. Now, a violation of the Sunshine Law and the Public Records Law is probably not moral turpitude, although it could, I suppose, as some circumstances arise. Ethics law, if it's unethical and you knowingly violated it, maybe would rise to moral turpitude. I think the committee wanted to not limit us to felonies or misdemeanors of moral turpitude, but also add to the list any violations of the Sunshine Law, Ethics Law, or Public Records Law. Then people said, well, and the committee said, well, what if it's inadvertent? Or what if people start witch hunts? Or what if people try to do gotcha moments to trick people into a violation and they unknowingly violate it? Should they have to forfeit their office at that point? And they said, well, maybe we should temper it with the word knowingly. So it would only be for knowing violations of Sunshine, Ethics, or Public Records Law, since they're not moral turpitude crimes.
you know, I've got two sides of this coin. You know, I'm for it and I'm against it, and I'll explain why. You know, like I said, knowingly, it makes it really tough, you know, because then it takes us or somebody to prove that somebody knew something. But on the other hand, we all have got to go through ethics training every year, you know, and they kind of talk about a lot of things, your do's and don'ts, okay? So that's one side of the coin. The other side of the coin, just like you just said, Ralph, you know, if the word knowingly is not in there, and when they came after a witch hunt after Nancy and myself, they said they could file an ethics complaint, and then, you know, where do we stand? If you want to get somebody out of office, you file an ethics complaint. It costs the city money every time, and you know, so, you know, I just don't really know how to even go on between 3 and 5 here. It just really...
Then you may not want to pursue it. You may want to leave it as the existing charter says is convicted of a felony or a misdemeanor involving moral turpitude, which are, you know, higher level criminal activities. Where, you know, Sunshine Law and ethics and public records are not necessarily criminal. If they are found that they were knowingly violated, then it'd be a misdemeanor. But it probably, in most cases, wouldn't be a misdemeanor of moral turpitude. Although it could be.
City Attorney, one other thing that was, when you talk about Sunshine Law, ethics laws, and public records, on Monday night, you agreed to add the election laws to that.
Nobody agreed, but one of the members of the citizens suggested it.
Okay.
I don't know that we were even in agreement with these, but there was also a member of the public who made a citizen comment that thought they should add election laws to this list. You know, if you're adding more and more reasons for forfeiture,
because election laws,
there's a possibility that could be used for politics instead of removing members who really have committed a felony or misdemeanor or moral turpitude now, we get into using this system for politics to try to replace people more easily.
I guess I don't understand what we're calling moral turpitude either. You know, where's that fine line?
Moral turpitude comes out of case law, and it's things like stealing, things that are morally corrupt, bribery, child pornography.
Yeah, moral.
I would think a DUI. DUI is a felony, so you'd be out for a felony. I'm not sure. I know repeat DUIs can rise to felony.
Inadvertently.
I think
And
election
so-
laws is a good thing to put in there.
Maybe it's good to have a high bar, maybe it's better to have a lower bar. It's kind of a matter of public policy, but realize
I'll go with
you open
whatever-
the door for more
I'll go with whatever
actions.
the majority says, you know. Like I said, there's two sides to that coin, the way I look at it, you know.
I like election laws to be in there because I think that it's abused quite a bit. And I think that.
There was citizen comment made Monday night, pointing out that there had been a prior candidate who had violated the election laws and had been fined, and thought that was a recommendation to include election laws because
I liked it, yeah.
So the election laws include things, and I'm sure you're all aware, if a flyer went out, it didn't have the disclaimer on the bottom for a PAC, or if a campaign contribution was accepted by a treasurer that exceeded the legal limit, the things that are in your campaign handbook. So if something were to happen in your election, then that could be a violation of the election law. The other thing is to realize sometimes people put a lot of trust in their campaign treasurers. So a treasurer might be the one doing the accounting or the books or submitting the reports. If the quarterly report's a day late, that's a violation of election law.
and
The
that's
reason I think it's important, I guess, is because that's a part of how you're handling what you're doing before you're either elected or not elected, okay? It shows your conscientiousness, your diligence in looking at the rules and regulations, I guess.
Usually, if there's a violation of the election law, the penalty in the Florida statutes is something like $500. It doesn't mean that you can't take your seat in office, even if there was a violation during the election, unless it's an egregious violation.
Could we put in this something like, if you're fined over X, if you're found guilty and fined over X amount of dollars, that,
I don't know that you could put the penalty in terms of the number of dollars of the fine,
Okay.
but what the committee has recommended is they put in the word knowingly. So that is, for example, in the case if your campaign treasurer failed to file it and you didn't know, or a PAC sent around an advertisement with your endorsing you, but you didn't know, they didn't put the disclaimer on it. It was nothing to have to do with your campaign. Some other third-party PAC violated the election law. This way, knowingly would have to be attributed to the person, to the commissioner.
okay.
For example, in the election law scenario.
Do you think there should be something in here that talks about having been convicted by, or there's maybe another word for convicted, but found in violation of the Sunshine Law by the person who oversees that, the committee that oversees that? That's what I'm trying to say with the word conviction.
So for Sunshine Law, there's no committee, it's a circuit court. It's either the criminal court or the civil court. For a criminal court to find you guilty, they'd have to find that you knowingly violated. And then there's also the possibility that you could plead nolo contendere or no contest.
But the ethics laws fall under the Ethics Commission.
The Ethics
versus-
Commission will issue orders, and in their orders, they'll have a detailed recitation of facts. And sometimes they'll say whether someone knew they were violating it, or they'll say, although they did not know, this is a violation, and they recommend penalties commensurate with the degree of violation and whether the person knew or not, that what they were doing was wrong, or in violation of Chapter 112, rather.
Do we have any public comment on this one?
And 50th Avenue. I'm not sure if I'm clear, and I wasn't there for all the discussions, but I'm not sure if I'm clear who's going to find out if they knowingly. I mean, I don't know that it's not going to be the commission sitting down and going through it. Because you use the word knowingly, you guys decide, I knowingly, whatever.
If the 3 passes and 5 doesn't pass, it would be the commission. If 3 passes and 5 passes, then it would be a special magistrate. Question number 5 would send forfeiture proceedings to a special magistrate. They're 2 separate questions. Conceivably, they could both pass, both fail, 1 pass, 1 not pass.
And I don't think it was the intention of the committee to have our BOC be the judge and jury.
That's why we have the ballot question number 5.
Then why, then if Doreen's case was, with her comment, couldn't ballot question 3 and 5 be combined?
We have 4 also, forfeiture of office after 3 unexcused absences.
Yeah, but that's
We could
a
probably
different-
combine 3, 4, and 5.
Well, I don't think 4 is really in the same vein, in the same thinking vein as 3 and 5. So I would like to see 3 and 5 be combined and 4 be separate.
That's possible also.
Makes more sense.
I like that.
I like that, yeah. Okay.
Any more public comment?
Oh, can we add, should we add the word election laws?
No, we're talking about 3 still.
Did we think about using the word election laws or not when we're talking about sunshine laws, ethics laws, and public records laws? Or ethics, or election laws? Should we add election laws or just forget it?
I think you just forget it.
Forget it. How high up is the, doing something against election laws really? Does that mean you can't hold office because of that? Because of some inadvertent thing and going through that?
No, you knowingly violated it.
And half the time, the county takes, years to even figure anything out, if it ever gets to them.
True.
They have a Florida Elections Commission, similar to the
Takes
Florida
them a long
Ethics
time, too.
Commission. Yeah, it takes them a while.
So the bottom line is we're gonna combine 3 and 5 then together, was that it?
Okay.
And then 4 was gonna stand by itself.
And we're not going to include the word election laws.
You want to jump to 6 then?
How about 4?
Okay. 4 is failure to attend 3 consecutive regular scheduled meetings instead of 4. And I think we could take out the word scheduled, because all meetings are scheduled, so we're looking for ways to simplify the language. I don't know that scheduled adds a whole lot.
It actually might. If you have a special meeting, if some commissioner is gone, and they already have maybe 2, have missed 2 meetings, and then a special meeting is called and they happen to be out of town.
We didn't include special meetings, we just include regular meetings.
And workshops.
Right, but I'm sorry, I thought you said take out the word scheduled.
Take out the word scheduled. It's a regular scheduled meeting. The committee did not want to include special meetings because no one knows when special meetings are going to be.
Okay.
People know second Tuesday and fourth Tuesday are meetings and workshops. So it would be, you'd have to miss basically a month and a half in a row without excuse.
I think this one should move forward.
Okay, so take out the word scheduled meetings there.
Yeah, I don't think it adds anything.
Okay, thank you.
Any public comment? Do we have consensus then to go
Yes.
forward?
Yes.
Okay. Let's keep it moving now. Number 5, forfeiture proceedings by special magistrate. We're going to combine that with number 3. But doesn't this one say that the board is the judge and jury?
Number 5?
5.
No, it points to special magistrate.
I think the existing charter leaves it to the board, and the proposed charter amendment would give it to a
Gotcha, right.
special magistrate. To hopefully remove politics out of the situation.
Any discussion from the board? My first thought is it should be amended. Consensus?
I'm sorry, Mayor.
Number 5.
Oh, well, it's going to be included.
Well, but we didn't discuss the wording on it,
Oh, okay, all right.
so I just want to make sure it's good. So, do we have consensus then to include, do it
Yes.
just with the same one? Okay. Number 6, adjustment of district. Oh, I'm so sorry. Go right ahead.
On 5, is that what, okay.
We're back to 5.
Helen Palladino, 13319 Boca Ciega Avenue here in Madeira Beach. Great idea to tie 3 and 5 in one, because if one passed and one didn't, it would potentially be a nightmare. The only thing I'm thinking of now is, depending on what has been violated, a sunshine law, an ethics law, or public record law, there are different avenues, I think. You're going to have a criminal judge determine if it was knowingly, or an administrative law judge, or an ethics commission. What happens now if we push this through? It looks rather quickly. We're going to have a special magistrate determine that Maggie Black violated the sunshine law, and she knowingly did it. And then as it moves up the chain, what if the administrative law judge finds that she did not? A year later, what do we do?
I didn't.
Because-
know that.
'cause-
I mean, so give me your scenario again, I got
Okay.
lost. So the first example was who's going to adjudicate?
Right. Okay, it has to be knowingly, and we know that we don't want the peers to do it, which is the basis of number 5, which is good, because I don't think you want to vote against your fellow commissioners, or that puts everybody in a bad spot. So I do like the idea of somebody else doing it. The problem is, if I'm a commissioner, and the way these sunshine violations are thrown around in this city, and we all know that they are, there's probably 1, 2, or 3 of them pending at all times, unfortunately. While that's pending, if I have a magistrate decide that I knowingly violated it,
But it wouldn't be
then
while it was pending.
what's I've lost my job, and now I've got to go and do another hearing in front of the next one. I mean,
I thought that it would have to be adjudicated by the court to have violated the sunshine law, and then it would be brought before the special magistrate.
Well, it could be
Am I-
brought to the special magistrate as a matter of first impression too, if nothing had gone to a court. For example, someone came to the city council and said, I have evidence that these 2 commissioners were talking about city official business, and here's the tape, and here's the video, and they play it, then there's a vote, we refer this to a special magistrate, then it goes to the special magistrate.
Okay.
Then he determines whether it's knowing or not, and decides the final decision on forfeiture. So it's possible it may not go to a judge unless we want that to happen. If it goes to circuit court, it can take a year and a half to go through the system.
I honestly thought that the process would be whether each one of these steps would go before the proper administering
Right.
authority.
Your Ethics Commission
And
or
then would be found, whatever that ruling was.
right.
Then in number 3, you would say, is found to have knowingly violated the sunshine laws, ethics laws, or public records laws by the Florida Ethics Commission or a court of competent jurisdiction. That would go back into number 3. But
Grace,
then it would have to go through those
do you
other
remember sitting through that?
systems, which do have more due process. They have investigators, they have probable cause determinations, they have state attorneys. So that system is more set up. We have problems here prosecuting because we're not really set up for prosecutions, you know.
That was
So
my
maybe that's a good
impression.
idea.
But city attorney, it
I
does
thought
say,
it would go through the process and then a finding of, yes, Helen knowingly violated this law, and then I could go in front of you all, peers, and say, hey, you know what, I want a special master to really hear.
And quite frankly.
I have
if
2
it's in-
trials.
If it's in the charter, if it's in the charter that you
Yeah.
knowingly violated and the person is found that they, by a court of law or the Ethics Commission, they'd be stupid not to just resign. I mean, because it's firmly says in the charter that if you knowingly violated these laws, you've been adjudicated by the proper commission, court, or whatever.
Why don't we just say, we're gonna take the word of the state of Florida, assuming that when they write their decision or their opinion, it says knowingly, or willfully, or with knowledge, or, I mean, why don't we just take the word of just get rid of section 2.3 altogether and not replace it?
And not what?
And not replace, I mean, charter amendment, charter amendment number 5. We're saying, we don't want the Board of Commissioners to determine who knowingly violated a law. We would rather it be done by special master. So now we've got another layer. We've got the layer at the Florida state level, that it's got to go through the process, someone's got to investigate and talk to my witnesses and talk to whoever accused me's witnesses, and come up with a probable cause, I guess, and then it goes to a hearing, and then evidence is taken, and then the Ethics Commission or the administrative law judge or the criminal judge, who, depending on the violation, then makes a decision, yep, Helen Palladino knew exactly what she was doing and she violated that law. I think that should disqualify me from being a commissioner.
It shouldn't?
Should,
Should, okay.
that alone.
Okay.
So what number 5 does is ensure that someone other than the board then is making the decision to
Correct.
take one of you off, so that you're not voting for your fellow elected officials. I think the worry is that it could fall into politics where a judge has found you knowingly violated the sunshine law, but for political reasons you don't want to kick the person off the commission, so you keep them on anyway. Special magistrate is a trained lawyer, and they're trained to look at and read orders to determine whether it was a knowing violation or not. It's sometimes, even when you read the order, if you read some of these ethics commissions, recommended orders and final orders, you can read the whole thing and still be confused about whether it was a knowing violation, whether that was an inadvertent or a knowing.
So you're saying they don't actually say in there knowingly or inadvertently?
Sometimes they do and sometimes they don't.
Okay. So if I have an ethics complaint against me right now, and I run for office again in March, and I win, and then in April, they come back and say, well, you knowingly violated that law. So at that point, I'm off the board right after the election.
And you may want to have, in that case, add a time frame during the term of office, so it's not from prior terms of office.
But if you say
It's just,
that.
if you say this, say that you were 18 years old or 22 years old and you were found by a court to have violated ethics law, but now you're 50 and you're on the commission, should they be able to go back in time 10, 20 years and take you off for that?
Yeah, I think they should, because the way that runs out of Tallahassee, if somebody turns an ethics violation in on me today, it could take 3 years for those people to get off their duff and get it answered. And I could be in 2 other terms before they would do that. That's what I'm saying. When it comes down that somebody willfully violated it, I think at that point, they're off. I don't care if it's the first day after an election and they just got elected, I think they should be gone.
Who's to determine that?
If the judge or the ethics violation comes out and says John Douthat willingly violated an ethics violation, I should be gone, period.
Okay, and then so maybe we say, in the event that the state of Florida does not make a determination of knowingly or willfulness, then we'll use a special master.
Well, we're trying to avoid the commissioners voting on each other, so we need to.
No, I know. I said, then we'll use the special master, number 5.
Special magistrate, right?
Yeah, magistrate.
Yeah, magistrate.
I'm sorry,
Leave
magistrate.
number
said
five.
master.
Same, well,
We
same
understood.
thing, but, okay.
Ralph, doesn't the current charter use the term that the BOC may remove an existing?
No, it says the
Commissioner-
commissioner shall forfeit his office, and if he, A, B, C, D,
Charged with conduct
says shall.
constituting grounds for forfeiture.
The trouble is, it doesn't specify any procedure for this board to vote on their own members and how that would happen, so the committee wanted to put some procedure together to have an independent, non-political body make the decision once it's referred by the commission.
I'm just trying to think of a way to get,
We could think about it between now and first reading.
Yeah, it's just tricky
get
wording
made-
in here and how it
to get,
goes.
we just need a decision made by somebody other than the board
Right,
that it was knowingly.
I agree.
And maybe we say, we'll take the word of the administrative law judge, the criminal judge, the ethics commission, and if for some reason their opinion does not indicate knowingly or willfully, then we have a special magistrate make that determination.
I agree with that. I do.
And then we just have to live with the fact that it's a 2-year process.
That's on a good year.
Yeah, 3-year process.
Okay, I'll make that change to number 3, and
Okay.
leave number 5.
Thank you.
And we can look at it at first reading.
Thank you.
And Ralph, can I ask a question too of you? It's on page 6, down the last sentence. Well, what does it mean when it, I mean, to me, it just covered everything we've just said. The decision of the special magistrate is final, but the special magistrate's final decision may be subject to judicial review. I mean, doesn't that, what is that not supposed to cover if it's not covering exactly what we've been talking about for the last 10 minutes?
You could take out the comma, but, because that's, you can always go to court. So you could just take that out. It's not necessary to grant the court jurisdiction. We really can't. The court has jurisdiction to review final decisions by a city. So it wouldn't go back to the city commission. It would just be final at the special magistrate. What this is saying is just that your next step is circuit court. You don't go to the commission.
Right, but the decision by the special magistrate is final, so it ends there, even though you might want it reviewed.
You could take that out if you want to.
I'm
It's the
just
law
asking
anyway.
why it's
It's just explaining what the law is, but you could take it out. And it's explaining that you don't get to go from the commission to the special magistrate back to the commission again with an appeal,
Okay,
that it
but,
would have to go to court. I could take out that last part.
I just want to say, at some time in the past, we did have commissioners that were found, the previous commission, there were people found that had violated the sunshine violation, I believe it was, in a court of law, but nothing ever happened.
There was nothing in the existing charter that says a violation of sunshine law.
Oh, okay, so it was just a moral,
Felony or misdemeanor of
Oh,
moral
okay.
turpitude.
okay, I was just trying to figure out how that happened, okay.
It's conceivable a sunshine law could rise to moral turpitude if it involved some kind of bribery or something like that. But it was just an inadvertent violation, or even at the direction of the city attorney to vote on something, and it turned out there was a violation. That wasn't a crime or a misdemeanor of moral turpitude.
Okay, I just wanted to clarify, so it's going to be covered, whatever.
So all we had previously was just moral turpitude, which, as you say, leads for a very broad interpretation.
Moral turpitude
In
is a narrow area.
Oh.
Misdemeanor, sunshine law is broad. Sunshine law violations of moral turpitude are much narrower, smaller. If you were fixing a contract, or you were doing a bribe, or stealing, or embezzling is part of your sunshine law violation, those would all be moral turpitude.
And, for example, ethics would have fallen under the commission ruling, but it wouldn't have fallen, it wouldn't be under moral turpitude then.
Florida Commission
We
on
have-
Ethics doesn't make misdemeanor findings. Those are only done in criminal court. So Florida Ethics Commission can assess penalties and make findings. The governor of the state of Florida can remove a commissioner for an ethics violation or a violation of law. But in terms of what we have in the forfeiture, it's either a felony or a misdemeanor of moral turpitude. So ethics, there conceivably could be ethics violations that are prosecuted criminally, like bribery, those kinds of things.
I don't think you have to keep telling me who you are.
Okay, Helen Palladino, once again.
Who is she again?
Our existing charter says, vacancies, forfeiture of office, filling of vacancies, 1 and 2 and 3. 1 is vacancies, 2 is forfeiture of office. And then there's 4 existing reasons right now where forfeiture of office. Lacks the qualification because they moved away. Violates any express prohibition of this charter. Is convicted of a felony or misdemeanor involving moral turpitude. And D, fails to attend 4, soon to be 3, probably, regular meetings. And now we're going to add another one that says violation of these laws. And then the very next, then we're going to say that Board of Commissioners doesn't make the decision. We're going to leave it up to the state, and then if that decision, then the person's out. But we would never leave it up to the state to make a decision whether they missed 3 consecutive meetings. That would have to be the board. Or maybe we just say special master. I mean, that's pretty easy. I don't want to make it so that all 5 reasons to forfeit your office has to go through the state of Florida and a magistrate. I don't want it, so that's something.
The sunshine, ethics, or public records are all going to put it in D or E.
Yeah, just put it all under D in that case.
E, yeah.
For E, right. So just something to think about. I don't want someone to interpret that to mean, oh, okay, well, I missed 3 meetings, but I need someone to determine that properly, and therefore I'm going to continue to be a commissioner and whatever.
Next, we have ballot question number 6, adjustment of district boundaries every 5 years versus 4 years, was it?
We currently do 4. This would make it 5, I believe, to keep it commensurate with what we thought the census was happening and with growth in different districts in terms of having new condominium buildings with more residents.
I thought it was every 5 years, according to this.
Oh, let's see. It's every 4 years now. 4 is stricken through and 5 years replaces it. If you look at the strike through and underline on the bottom of the page 7. And I'll confirm that here.
On B, at the beginning of B, it says every 5 years, the Board of Commissioners
That's
shall.
an added.
That's
That was
the
added.
added one?
That's
Okay, that's the added
underlined
one.
added.
Underline language is added.
Okay,
You'll
Yep.
see the 4 in the middle of that paragraph.
okay.
And 4 is stricken through and replaced with 5.
But I think we were going to change, Ralph, the the last word of the new ballot wording. The The charter amendment would require that every 5 years, the Board of Commissioners shall by ordinance review and if necessary change the existing municipal district boundaries to ensure that each district shall be approximately equal in number of electors, not residents. That was discussed on Monday.
Yes.
We changed it in the actual charter, but we need to change it in the ballot summary question. Yep,
Yes.
good catch.
Okay. Public comment? Got it. So we have a consensus to go forward on this one then, right?
Yes.
Next, we have ballot question number 7, collection of signatures to run for office.
I think here I had a recommendation that we change the word since to the word because, just for better clarity.
Where is that?
Since candidates.
Instead
are
of collecting
elected.
signatures within their district, because candidates are elected at large throughout the city.
And I just have difficulty
Yeah.
figuring out why, if we have districts, we are not really putting our priority, at least in 50 signatures, to obtain from our district. I know that the discussion has always been that District 4 has so many condominiums that they couldn't possibly get, or that it would make it very difficult. But I don't think the process should be easy, I guess. But I do understand that it's hard to get into condominiums. But maybe 50 of those signatures should be within the district. Or why do we even have districts if we're not supposed to get support from our districts first?
I think we need to know people in our districts and what's going on there before anything else. So I think it should stay within the districts. And if it is voted to go outside of the districts, I think instead of being 50 and 100, it should be 100 and 200 signatures.
Oh. I think 50 is fine, but I think it's better to stick within your district because that's the people who you're representing. And at first I thought maybe that it's not fair to the people in District 4 because of the condos. But it's the same thing. You still need to talk to those people. That's who you represent.
If we have districts, right.
But you can't knock on doors. I mean, that makes it extremely difficult. You can't knock on doors.
Right,
and
I know.
When you. Yes.
Stuck.
But
Jump
on the
out.
other hand,
Great advice.
it more opens the election up if everybody goes to everybody in the whole city, because there's so many people out there that think because districts 3 and 4 are running this time and they live in 1 or 2, they don't need to go vote. And I've heard that over and over again. You've heard it.
Certainly have, yeah. People still do believe that it's only if their district has a candidate that they need to go there, because they don't realize they can vote at large. So there is a double
Disjoint
thing,
there.
but it's always been that way.
Well,
I mean, it's
I
not
think
something.
that's
But this
something-
would correct it.
I
then.
think that's also something that our media person should be putting
Right.
out there. I think that, to let people know, versus, so they
Educating.
understand it better.
Educating
Yeah. Yeah,
the
educating.
voters.
Yeah.
But with regards to the chair's comment, I kind of agree with you, okay, but it is, we're talking about the districts at one time and then we're talking at large. So I just feel that there's that it's important, if we're still 4 districts, that we have the support, and we know we have the support of our own district to a certain, like with that 50 votes, okay? I'm sorry, 50 candidate petition forms. I guess I feel that we should still have 100, but 50 of those should be required from our own district. If we're still having the problem and we're still having the feeling that District 4, it's very difficult. We want to get 100 signatures because we don't want to pay that extra money, but you know what I'm saying? And we want to do it just to show our involvement, but it's just too difficult to get 100. So at least if you get 50 from your own district and then 50.
You can't do it both ways.
Why?
Because the election board checks the signatures, and it checks 50 signatures from my district. And if I've got 100 signatures on there, now you got asking the election board, okay, are 50 of these good and 50 of them outside? I think you're asking.
Yeah. It's going to be
Yeah, I
a
didn't think of that.
little hairy with them.
Didn't think of that.
I think we just leave it like it is.
Well, there were a few housekeeping items that made recommendations about some changes, because changing a nomination petition to candidate petition form made more sense. So there were just some housekeeping terms that we thought clarified.
And I think that's good.
But we didn't include, or was the intent to not include the, discussion of, or including that in the ballot wording, the 100,
But if you're not going to make the changes to the ballot numbers in terms of, what we were trying to do to open it up citywide, if you're not going to do that, then it seems as if you just
leave it.
take this out and leave it the way it is, unless, Ralph, there's something glaring that we were trying to clean up. I don't have the charter.
Yeah, the only thing there is changing candidate petition to candidate petition form. I don't know that that's significant enough to
No.
want to put a whole, to go through the
No.
whole ballot thing. I think there was some concern last time about ballot fatigue.
I think we just drop that.
I like to leave it the way it is, and
Yeah, don't
I
we
would
just
leave it
drop
the way it is.
leave it the way it is.
When you say leave it the way it is, go with the existing charter and not put this on the
And
ballot.
remove
That's correct.
this as a ballot question.
Remove it as a ballot question.
Right. Thank you.
Any public comment on this one? Next, we have ballot question number 8, adopt state law for recall procedures.
This is one, if you have ballot fatigue, this repeats the state statute and makes a reference to it in the charter. The clerk thought it would be helpful for people that are trying to recall officials to know where to go, so they put it in the charter to lead them to the right area. But, they can find it on their own anyway.
So you're recommending just dropping this one also then?
If you're worried about ballot fatigue, it doesn't add anything to the existing state law, it just cross-references it in our charter.
And I think we should take it all down. Yeah.
So we have no reference in our current charter as to what to do with a recall. It seems to me.
Right, you have to go to Florida statutes.
Okay. But
And this would just direct them to the particular statute.
because currently there's nothing in our charter, because I know that there was quite a bit of confusion about the process.
There's nothing in the charter right now, you just go to state statutes.
So,
And this didn't add anything to state statutes, it just referenced you to the state statute. And you're probably bound by going by the state statute, because I think the state statute says this is the sole and exclusive means for recall.
Okay, because then wouldn't
It is a confusing statute, when you go to the statute, it's a bit confusing, but we can't change the statute by
Right.
charter.
and it's the responsibility, is it not, of the city clerk then to tell any party that wants to
Well,
file
we don't-
something for a recall to where they're supposed to go? Is it her responsibility? Is it the city clerk's responsibility? If it's not, then maybe this is helpful, okay, in at least guiding the individual where they need to go.
and that
But how is it
wasn't
gonna guide
that her comment?
I think that was the intent, yeah, because she's not really supposed to give legal advice.
Oh. Well, then maybe it does have a purpose. But who would look at it? Who would, if we added this to our charter? Oh, that's right, the people who, you'd say, look at our charter. And it tells you exactly where you're supposed to go. Well, then in that point, then maybe it should be left in.
I think the clerk wanted it in there if it's not too much to put in.
I mean, what would it hurt? We're narrowing down, we don't have, it's not as cumbersome as the first go-round anyway,
Right.
so.
And it says it very succinctly. No, I think maybe, I don't think we should remove it. I think we should leave it. Second thought. Sorry.
We can leave it in for first reading and you guys can think about it a little bit. But for right now, we'll just leave it in. And
Doreen,
the city clerk's not here tonight, I hate to take it out when she's not here.
how much, with all these changes, does our charter change? Like from 45 pages to 50 or 45 pages down to 40? Do we have any idea where we're at on the city charter?
It's only
I
like
don't think
13
we added
pages.
that much, I mean.
It's only like 13 pages.
Well, however, how many does it
Well,
increase or decrease?
one of the questions is to take out the city treasurer, so that would take out a page maybe. Not a page, but
We've
a section.
actually, I think overall, we've ended up minimizing rather than increasing, so to
Okay.
speak.
That's kind of what I was just trying to figure
Yeah.
out.
All right, to be clear then, to number 8, we're in favor of going forward with it as is. Is
We're
that
just gonna
correct?
move it into the
Yes.
first reading. And then
Okay, first reading,
make a
right.
decision then.
Any public comment?
It won't,
In the description itself, I mean, not in the charter amendment, but, yeah.
okay.
Notices people or whatever, that the recall provisions are set forth in this particular section. We used to give people, I read it, and I went, well, what are the old ones? Were we replacing it? I assumed it was a replacement of something.
I think that's correct, I would first think, okay, what's coming out? Are they making it worse or better?
Well, you have to show what's coming out, so, but you still, it's confusing
Let's
to
remember to
not
go to
know
the
it.
microphone, and I can add that in too. It doesn't hurt anything to add that in.
Helen Palladino. I'm just saying in the 75 words that we have for the description for voters, maybe mention that this is not, we're not changing anything. This is just a notification. Because when I first read this, it just says this charter amendment will adopt and the recall provisions set forth in Florida statutes 100 point blah blah. I was like, oh, okay, so now they're changing. What was it before? I got to go look at the charter and see what our charter, and it's silent. So I've learned now that this is in there just because we just want to give our citizens good information, and we don't want the clerk to have to give out legal advice or whatever. And so maybe we just say that. We want to inform our citizens of all options open, and therefore we're going to include the statute. Or some, give people a reason to vote yes, if we want it in.
Good point, very good point.
You could say this charter amendment would notify residents of procedures for the recall of elected officials in Florida statutes because the city charter is currently silent regarding procedures for recall.
Okay.
Except it sounds like it's written by an attorney.
It was.
Ballot question 9, induction of newly elected commissioners.
We'll put together a layperson's guide to the charter amendments too.
Cliff notes.
And what was the reasoning behind this, Doreen?
There seem to have been at times in the past where, because of the date and when it fell for the election and in the cycle of when the meetings were held, that there was at one point a delay of a couple of weeks simply by not having scheduled a meeting, as I recall.
Well, it says the next regular meeting or something to that effect in the charter.
It says on the first regular meeting.
Right.
And so depending on how it fell during the month, it ended up that it was
The
maybe
first meeting
5
in
weeks
April.
later before they were actually placed in office. And I think it's important that, speaking from my own opinion, I just think that once you're newly elected, you need to get in there as quickly as possible. And that the prior commission should honor getting the newly elected people in and not having business being conducted by the old board.
You
So
know,
there will be a special meeting held in November to appoint you for the November election and a special meeting in March for the March elections.
the March
You wouldn't
election's
wait.
always on the second Tuesday. So if we move the March meeting, or BOC meeting, to the third Tuesday, then that would cover that, rather than have to wait till April. In the
Yep.
past, I know the year that we got elected,
Could
they
do that.
moved the BOC meeting to the Tuesday before the election. And then they held a special meeting after that, so they didn't have to appoint us for that one. They waited till the next meeting
Right.
in April to appoint us.
So it was about 5 weeks.
Yeah, so if we change it to read that the March election is held the week after, or the BOC is held the week after the election, then that would eliminate that. It would automatically, and then they would be appointed the following week.
We said it would have to be before the end of the month.
So, well, if you're holding it on the second Tuesday is the election, the third Tuesday would be the BOC meeting where the people would get appointed.
And then the 4th would be the workshop.
And the fourth would be the workshop.
So this would put that in the charter, so it would have to be done that way.
Yeah. That to me makes the most sense.
Right, so it's already set up and everybody knows it, and it's not a special meeting being called. And
Right.
who calls a special meeting? No mayor, new mayor, city
Right.
manager? Yeah, just put it in there and it's a
Current
done deal.
governor, former governor.
Yeah, it was 5 weeks for me too.
The one other thing I
5
was
weeks from
looking
the
at
time of the
changing.
election till the time.
So this is good language, the way it is, it would accomplish that, because right now you don't have your first Tuesday, or second Tuesday and fourth Tuesday in
Yeah,
the
we
charter.
just have to change
I
our
think
meeting
those
date.
come up in, or, yeah, you could just,
Change our meeting date.
and this would make sure that every future commission does that, even if,
Yeah.
so this language would accomplish that.
Okay.
But the other thing I'd change in this is the 60 days to adopt the
Oh, yeah.
board procedure, because we never get that done in 60 days after election. It's just something, I don't know if it was just so
It's too much being
pretentious,
put on the plate at one time.
too much first going in, or, and I think everybody has the same problem, so I'd at least go 90 or 120 days out. And, you know, you're going through budget at that time, it starts up, and it's just, like you said, there's a lot going on.
I'd be okay with that.
You wanna go 90 or 120?
Go 90.
90.
Okay.
Is everybody okay with that? Any public comment? Ballot question number 10, remove city treasurer from the list of charter officers.
On this one, I had some additional language, I thought. During our citizen meeting, there was some suggestion that we ought to state that we're not getting rid of the city treasurer and finance director. So at the end of the sentence, it would say, and place the city treasurer, finance director under the direct supervision of the city manager,
Well,
pursuant to ordinance, I guess.
That's needed to be done for a long time.
I'm not really in favor of it,
So where do you want him to be?
where he is now.
Under the city manager?
Then what's to say?
It's very convoluted what it says. I always thought. Because it says the city manager hires the
And fires?
finance director, yet he has to come to us for approval of it, and that whole scenario is just kind of,
And Madam Mayor, if I may, one of the things that provides for additional challenge is that it says that the finance director is, in essence, hired by the city manager, then we have to obtain confirmation, but it doesn't speak to a situation whereby if you were to remove remove that particular individual, is that something that the city manager has to recommend approval and then go before the Board of Commissioners to seek confirmation? It doesn't speak who's responsible for the evaluation, and you can have a situation whereby you would there could be an opportunity for conflict with regards to a commissioner directing the finance director to do something. So the language that is provided for in the charter carves out the city treasurer and provides them a different standing in the organization as opposed to any other department director. And it is very unique to see a situation whereby a treasurer or finance director is placed in the charter as in essence, charter officer. In most situations, the manager is responsible for, because if you look at the duties and responsibilities in the charter for the city manager, it intertwines with the finance director. The city manager is responsible for the day-to-day operations. We're responsible for providing the financial data and information to the Board of Commissioners, is responsible for producing the budget. And so the duties and responsibilities are muddied as it stands right now in the charter. So that's why when we had the conversation of some things that we wanted to change, that none of your other department directors need to obtain confirmation. So we decided to say that it's probably better off that it is, the finance director is removed, and the aspect as far as seeking confirmation from the board, because I can tell you, even if you're going to recruit a finance director, having to have a situation where they have to be confirmed by the board makes the process that much longer. And if you're looking for good folks, you want to be able to get them as quickly as possible. So therein lies the rationale behind the recommended change on this one.
I like the change in the wording. I do think that, and if you read the old stuff on the city treasurer, it's pretty obvious that most of that hasn't been changed since 1949 when the charter was made, because city treasurer is a totally archaic word. I mean, I don't know why we don't just take that out. Can we take that out? City attorney? Right,
taking
but
the
no,
entire
but
thing.
see, it says the charter amendment would remove the city treasurer / finance director. In the proposed wording for ballot question 10, they still keep in that city treasurer wording. And I'm just suggesting.
It's in the charter.
Huh?
It's in
Well,
the charter
section-
now.
That's
City
what I'm just
treasurer's
saying,
in
why
the
can't-
charter now. He's just saying remove both of those things from him being a charter officer.
Let's see what it has
Both
in
of
the
those
charter now.
positions.
Let's see.
Oh, okay, and I'm just saying, I just can't, okay, yeah. Got it.
It's called city treasurer.
You know what I mean?
Yeah.
City treasurer in the charter, section 6.4.
Right.
That's not 6.54, it's 6.4, city treasurer would come out. I could take out the word finance director.
We
It
had to
just
list
says
both of
city
them. You had to
treasurer.
list
Yeah.
both of them because the very first sentence that's striked out, so that mentions
Says
both
of them.
Right, I'm just saying, the reason I
uh,
used the word Nancy.
city treasurer and finance director.
Right, the reason that I said that it should be directed, because I would think that so many people would say, wait a minute, I didn't know we had a city treasurer. You know, they
Right.
think, oh, this is the finance director, so that's the only reason I said it, but I do
Okay.
see where I see where you're coming from, you just.
This way, both
Deleting
people,
it.
people that knew it as one or knew it as the other would understand the balance, and probably want to keep them both in there.
Okay, right, to keep the balance.
My only concern with this whole thing, and it's probably stupid, but, you know, under the previous city manager, you know, you had to go through him to talk to the finance person. You know, if you went to the finance director without going through him, then he got pissed and the whole thing happened. You know, I think as commissioners, we should be able to go to the finance person and talk to him. I have no problem under Jonathan, he could care less, you know, if we talk to the finance or the treasurer, you know. But down the road, what happens if that changes again? You know, that's my only concern with this whole, this removal of this, you know. Where if he is a charter officer, then we can, as the commissioners, go to him and talk to him without any problem. I know when we first got elected, the mayor and myself went to talk to the finance director, to Vince, and all hell was raised over that. Do you remember that, Maggie?
Yeah.
You know, and that kind of scares me down the road. You know, like I said, I understand, you know, Jonathan has no problem with it, but if you get a person in there down the road after Jonathan that's controlling, that could be a problem.
It's like separation
Well, I think
of
you have to
duties.
discuss that with the person, you know, with the city manager himself. I mean, I think that, I don't think we should use any past experience, I guess, with what we have now and with what we hope we will have in the future. So I think that we have to, but I can see your point, you know, I know where you're coming from.
Those are
But
my
I don't think we
concerns
can
as
let
well.
it interfere with the good thing about having I think the city manager in charge of everybody is that this is a city the size of, you know, 4,000 people and 60 some odd employees. And I think that in a city lots larger than ours, there might be the need for specialized finance director who reports directly. But personally, I wouldn't go speak with the finance director even in this particular instance without just letting the city manager, giving him a heads up that I have something I want to discuss with the finance director and what does he think about it. I would always give that acknowledgement, I guess, to the city manager, just as a matter of respect.
Okay. I'm just
So,
saying my
yeah,
concern.
right. I see where you're coming from, though.
Do we have any public comment on this? Okay. All right, so I'm not sure where we stand on this one.
Well, let's move forward with it.
See what the people
Let
say?
the voters decide, that's right, it's the voters who will decide anyway. So you're for it.
We go 11. In 11, I wanted to change containing to concerning. In the summary.
Madam Mayor, if I may, with respect to the items that the board has discussed as it relates to what will be presented to the voters, is it the board's desires to potentially move forward with all these items, or did you, because I know last time we moved forward with 10, I didn't know if it was the board's desire to look to consider all these proposals that are on the table, or would the board want to prioritize or look to go with these in March and then the following in November? I just didn't want us to get through all of them and then decide that, okay, out of the 15 or what have you, we are only interested in 5 or 10, and then have to jostle as far as which ones do you want to present to the voter. So just something to be mindful if the board has a threshold that they're considering as to what to place on the ballot, because I did have a conversation with residents today, and they did mention the number of items that were presented to them as part of the charter amendments was quite lengthy, and they had some questions and some concerns related to that, and that was the residents of Madeira Cove when I met with them this afternoon. So just something that I think is germane to the conversation that the board should consider.
Well, we have turned down one as far as on my count so far, and there's not many left, so we'll see.
And we combine one, right?
And I think some of them are really minor and, you know, smaller in size and don't have the depth of the detail that we had the first go-round.
And on top of that, we don't have all the ones from the county and the state in there as well. It's just,
Yeah.
Yeah.
it's gonna be just us this time.
Yeah.
So maybe if you bring them all forward on first reading after you've sorted out and revised and combined, and then at the first reading, make that decision as Jonathan was saying, well, how's it gonna look? How long is it gonna be?
Okay. Ballot question 11, delete commission investigation procedures from the charter.
And it's really not accurate. I'm thinking what we're doing here is a little bit different. Let me read some proposed language here. The charter amendment would amend the section of the charter concerning investigations by the Board of Commissioners to delegate investigations to a charter officer by stating the Board of Commissioners may make investigations into the affairs of the city by appointing a charter officer to investigate internal affairs of the city. So delegation of commission investigation procedures would probably be more accurate, the way we finally wound up with the language.
So you're not really changing the intent of it, you're just changing the verbiage.
Right.
Instead of the commission conducting it, you're going to delegate it to another charter officer to investigate. If there's a problem in the city clerk's office, you might designate the city manager. If there's some other problem, you might designate the city attorney, that kind of internal affairs investigation.
And Madam Mayor, to the city attorney's point, that provides for the protection with regards to that interference provision that you do have in there, because if the board is to make an inquiry or get into an investigation, does it now infringe on the nature of the inquiry? Are you affecting city operations? Is it more so the duties and responsibilities of the city manager or the charter officer? Depends on the nature of the issue. So based on this language, the board still has the same authority to say, Mr. City Manager, we want to do X, Y, and Z, or Mr. City Attorney, we want you to look into X, Y, and Z. And then we as staff can follow the appropriate protocols to make sure in the event that there is an inquiry and investigation that due process and city policies are followed and doesn't put the elected officials in that precarious situation, because you are here to focus on public policy. And as far as there's any issues with the nature of city operations that you wanted to look in, we would, you would assign the appropriate party to look into it. You still have the same authority. You would just designate one of your charter officers, whether it's the city clerk, city attorney, or city manager, to look into the item more specifically and report back.
So the main things is that the city attorney would change this. On that ballot question 11, the city attorney would change the wording on basically really the delegation, to delegate by the Board of Commissioners, and then also the section of the charter concerning investigations instead of containing, right? That's where you really want to change it. Okay.
I think you may want to also add in here at the end of the actual charter language to do what Jonathan just mentioned. The Board of Commissioners, and this is in the bottom part, 4.10, the actual language, may make investigations into the affairs of the city by appointing a charter officer to investigate internal affairs of the city and report their findings to the Board of Commissioners.
Yep.
That way we close the loop and bring the findings back to you.
Okay, I would agree that that should become a ballot question, I guess.
I agree. Any public comment on this one?
The only thing I'm seeing is our charter, according to our charter, the only charter officers, if we take out the city treasurer, is the city clerk and the city attorney. I don't see where under city manager, it's named as a charter officer at all, or mentioned anywhere as a charter officer. Maybe that's kind of been our practice, but maybe we better make that clear as well.
I mean, I'm kind of lost. The city manager is in the charter as a charter officer right now. We just
Where?
on that
I just read Article 5, city manager. It doesn't say the word charter anywhere, and in fact,
In a different paragraph.
Oh, it is?
Defines what who charter officers are.
It's Article
Yes.
5, city manager.
right.
And so they're in the charter and they report directly to the Board of Commissioners under 5.2, removal,
5.2.
5.4.
I don't see where it says the city manager is a charter officer, that's all. So I just don't want this to be
Oh, you want to
confusing.
add them to 6.1?
Maybe.
I never thought of it
Because
that way, but it is
6.1
listed
says
there.
city clerk, city attorney, and city treasurer are our charter officers. And we're taking the treasurer off. So that only leaves 2.
The city manager is a charter officer because it has a whole article on its own. But it does seem a little bit.
It doesn't say it.
It's not in 6.1.
As someone sitting here looking at this,
We went into a problem with that when,
We ever change that
with
thing?
Mr. Crawford, in that his attorney thought that he was not a charter officer and we had issues with firing him. And somewhere in here, it needs to state point blank, the city manager is a charter officer, period.
And in most situations that I've seen, when it's disclosed and explicitly pointed out as part of the employment arrangement between the manager and the board, that is implied in some cases, that in most cases that effectively is a charter officer. I serve at the pleasure of the board. There is a section specific to how you are to employ a manager and how you are to remove a manager and the duties and responsibilities. In the front couple of sections of the charter talks about the city manager's authority. So in multiple sections, it's implied, and now it's not called out specifically in some of the other sections, but I think if you were to make the legal argument, and you would be able to show that the manager is in fact a charter officer, but we can we'll present the changes to the electorate and they can make the modifications to specifically call it
if I
out.
didn't like an investigation, the first words out of my mouth up here as an attorney would be, you've assigned this to someone who's not a charter officer.
Yeah. I think it definitely needs to be.
Because you even have a
Even-
section that says who they are.
Okay, I have an idea. We could go back to ballot question 12, or on to ballot question 12, and we could state, this charter amendment would expressly state the city manager is a charter officer with the power to call special meetings of the city board of commissioners. We could wrap it in there, and then I could put the name in 6.1.
Okay.
And we'll take the city treasurer out of 6.1 in that other, when we're removing the city treasurer.
And adding the city manager.
Yeah. Because there is that different list there in section 6.1, so we'll clarify with that new, with changing that list.
So we're going forward with ballot number 11, and reporting requirements to the BOC. Number 12, special meetings called by the city manager.
It's just housekeeping.
Is it?
Yeah, I think so.
You know, with regards to that, you know, what's the big deal with the city manager calling the mayor and saying, please call a special meeting? Why does the city manager have to have that authority, number one? Number two, you know, we've had months since we've been on the board that we've had 5 and 6 meetings in 1 month, you know, and that's kind of ludicrous, as people have pointed out. You know, just because somebody forgets to turn something in and it's got to be done by next Tuesday, we've got to call a special meeting. You know, I think that's BS. You know, I think we really need to start looking, if we're going to have special meetings, to really narrow it down and not make it because somebody messed up, either be somebody that works for the city or someone requesting something that they didn't turn it in on time or get it to us in time. And that's what happened in the past. We were having constant meetings, you know, and I think somehow, and when I was reading this, that's what I was kind of thinking about, that we were having more meetings you could shake a stick at, and some of the constituents stood up and said, hey, you guys are having way too many meetings. Why? It shows poor management on our part and the city's part. You know, so I think we need to kind of look at that while we're in this, you know, not that to write it in there. I'm not saying that, but I think we need to look at that, and I think, you know, the special meeting should come through the mayor and not the city manager. And if the city manager needs to have one, then he calls you up and says, what do you think? And then you make a decision and call one.
And that's no problem.
Yeah.
As
Yeah,
Helen said
I would
before, if
think-
it's ain't broke, don't fix it.
And you don't, and just don't answer your phone.
Well, normally that would be the case, okay? But what if the mayor, because right now, the mayor can call it or a majority of the commission, right?
Right.
Okay, but what if the mayor and one commissioner are out on the holiday somewhere, and we get a tremendous, either maybe a hurricane, not a hurricane, but, you know, a named storm or something, okay? And the commission has to meet, whether it's this commission or a future commission.
Vice mayor.
That's why I would think it's good for the city
Telephones work
manager to be
everywhere.
able to call a meeting.
But if I'm on vacation or out of the country or whatever, you can call me. It's not like, you know, I'm.
Well, but then wouldn't that make you still, not make you, but you would still then,
She would just
you
get
wouldn't be
permission.
calling the meeting, you know,
Well,
because you're out of the country. So I don't know, that's just my thought.
And Madam Mayor, if I may, certainly it's not something that, you know, the manager is going to utilize that as a mechanism to, you know, inundate us with more meetings, obviously, because the manager and the board would have to be there, but it also provides an opportunity if something comes across the manager's desk that is time sensitive, that needs to come before the board, and the mayor is not available, or the mayor can say, I don't want to have a special meeting at that time, then it puts the manager in a precarious situation that if I get something from Pinellas County, like we just did, and fortunately, the way it aligned for the appointment of an individual to serve on that joint review committee, we would effectively have to, put that off and, prolong some city business. So it's not something that, I would assume that no manager would utilize it as a regular reoccurring thing, but it provides that opportunity in the event that there is a situation whereby the manager needs to call a meeting. They do have that flexibility and latitude to do that. And I think, if I'm not mistaken, the board did discuss that as part of your procedural manual to allow for some opportunities in the event that the manager could call for a special meeting. And I think that this is cleanup to mirror the language that the board discussed in their procedural manual. And I don't have it in front of me, but I think it's a carry forward from the discussion that we had previously.
I do.
Of course.
I think I saw it in there too,
Yeah,
when I was looking through it.
Debbie doesn't cut any slack. You need to be prepared.
Yeah.
Actually, I was just reading it too, to make sure, just to familiarize myself with it again, to make sure.
She get way too much time on her.
I know, I'm not spending way too much time. I need a hobby.
Now I've got to find this
Ooh,
section.
jamming.
Special meeting. It says a special meeting may be called by the mayor, by a majority of the commission, or by the city manager with the appropriate notice, with no less than 24 hours notice in writing to each member and the public.
Okay.
And that's on page 11.
What are you looking at?
I'm looking at the procedural manual for the Board of
Procedural
Commissioners.
manual,
Yeah,
okay.
and here's where it says,
Page 11, okay.
or by the city manager with the appropriate notice.
So you already can call a
So we don't
special
even
meeting.
need that. Well,
Well, in your procedural manual, you give the manager the flexibility and the authority to do it. Is this something that needs to be memorialized in the charter?
If you would like to, you can.
If effectively, if that language in the procedural manual gives the manager the same authority, I think it's a duplication and there's no need to put it on the ballot to.
It's just one more thing. we
Right,
have to-
right, it's something
Yeah.
that's
Let's just
simplistic.
scratch it.
If we have it
Scratch it.
cured in here and we can effectively do that, then there's no point of putting that on the ballot.
but Ralph still wants
As
to
long as that-
put somewhere the
Yeah, I'll
wording
find
there
another
about the
place.
chartered
So
officer.
I'll find another place for the
Okay,
reference of city manager in 6.1. We'll squeeze that in.
okay, so we can remove that one.
Probably on the same where you removed the city treasurer.
And I assume we have no public comment on that one? Okay. On to ballot, question 13, special magistrate to replace the Board of Adjustment. What are the implications of this?
Housekeeping.
Yeah.
Housekeeping again?
Madam Mayor, I
Because
think
the
that's the process that you currently have in place now, where the special magistrate functions in that capacity, so this is
okay.
just cleaning it up.
Okay.
Do any cities still have Board of Adjustments, or is that kind of?
Yep, some do, and some have
Few and far
magistrates.
between, but yeah.
Raven's Beach does.
Oh, there's a whole bunch.
Yeah.
I go in front of a lot of board of adjustments around the state.
All right, so we're all in agreement to go forward with that one? No public comment? Ballot question 14, citizens initiative and referendum procedures. To require 10% rather than,
I think the moving of the 10% from the 25% is a really large area there, I would think maybe 20% if someone wanted to discuss that, but I think that 10% is too low because I think that it would perhaps bring frivolous petitions or
10%'s where the recall, the first round of a recall.
Well, it's
And I think they're bringing it in line with that.
yeah, but then they require another 15% for the recall.
But the question really is there something that the state supersedes all this anyway?
I don't know,
statewide,
does it
I
on
think it's
this one too,
10%.
Ralph? I don't know if it does on this one. It supersedes, the state is clear on the recall, but not on the, just if you want to bring a petition or an ordinance or something like that before the commission, that's what this involves, really.
The
Is that
state
correct?
statutes address a couple of things, recall and then amending a charter by citizen referendum.
Okay, but not
But they don't
citizens
address-
initiatives
Right, not for
and
ordinances and
referendum
resolutions.
procedures. Okay. I don't know, I just think that looking at 400 signatures, which would really be 10% of the electorate, is just awfully small. Nobody else thinks that?
Right, but most of the time it's gonna go to a referendum anyway. So then it puts it to everybody.
I guess I just think it's small.
I don't.
20% is 600 votes. Yeah, I just think 400 is just not a clear mandate or a clear showing that something really should be brought forward or, brought forward.
Could be compromised at
It shows,
15%?
it shows that there's some interest, okay, but it doesn't show that anybody's passionate about anything. And I guess I just have that feeling that it's a little bit too frivolous. I think, I would really feel better if maybe it went down from 25 to 20.
At the 25, it was, the last referendum that was done was a snack shack. The last one that went through and something actually got put on the ballot, and that was keeping the snack shack. And it was a challenge to do 25%, and that was back then, like 2007, when that was going on. And that's why I tend to agree with the 10%, because I've seen it in the action, and I don't know how the last one that happened that never went through because the commission kicked it out before, the one that Sam Baker did on something about height and density as a referendum question. So.
Well, maybe there's an area between the 25% and the 10% that we can think about a little more.
Well, you can recall somebody for a really frivolous
But we're not
reason,
talking
and
recall.
then you want to do something that people are trying to do an initiative for, and you're going to make them work twice as hard to get to where somebody's doing it.
Well, but the recall thing is
State mandated.
That's right, it's state mandated.
And that's where I think the committee was just trying to have some consistency with looking at statewide.
Had any other figures been brought about, Doreen? There was no negotiation like between the 25 and 10?
No, I think that we were just trying to be consistent with the various percentages and then looking at what the state requires too. So, in my opinion, if you're going to be, I don't mean to sound negative, splitting hairs over numbers, leave it at the 25. To lower it to 20 doesn't make it, it's inconsequential. But I do think that.
Why put so much pressure on the people who are trying to do it?
Right.
Well, I think that it shows that they're very diligent in their efforts, I guess. I just think that, I think I could go out and get 400 signatures and I'm sure I could. And work hard enough and you can get out and get them. But
I will say in memory of Sam Baker, he worked very, very hard and had learned the hard way, and there are other suggestions of revisions in here based on the confusing wording and to clarify interpretations that the city had at that time so that we didn't have that issue come up again in the future. So It really was the committee's recommendation at the 10%, but that's, again, it's up to you all to make that decision.
I think we send it out at 10%.
I go with 10.
I wouldn't mind seeing 15, but I'd go with 10.
Yeah, that's okay, I don't agree, but we don't all supposed to agree anyway.
All right, so we have a consensus to say no on that one.
Just say no.
Right.
Oh, just say
Or
yes.
did I read
Just
it
say
the wrong way?
yes.
Just
Say
say yes.
yes.
We want 10%. To go from 25 to 10.
Yeah.
Oh, right, I'm sorry.
You better be careful, Mayor. She'll send down that book that she has.
I'll show you where.
Any public comment on that one? And guess what? The last one, ballot question 15. Oh, but we've got two alternatives here.
This one's about the grievance committee, and we had charter review committee, and we had a civil service committee meeting, and we had joint meetings. And the charter review committee recommended alternative 1, and the civil service committee recommended alternative 2. And it's your prerogative or ability to reject one or pick the other, or reject both, or come up with your own idea, or some hybrid of these issues. So the Charter Review Committee wanted to keep the Civil Service Commission, but narrow the language in the charter to what they thought was essential. And that was to have grievance procedures and to review implementation of personnel rules. And we all wanted to recognize, of course, collective bargaining that's already occurring with the fire department. The Civil Service Commission wanted to retain the Civil Service Commission, but limit grievance procedures to terminations and give the Civil Service Commission final decision authority on terminations. For example, if the city manager were to terminate an employee and there was a grievance filed and the Civil Service Commission thought the employee should be reinstated, the Civil Service Commission wanted to be able to overrule the city manager and put the employee back to work.
Well,
So that would necessitated not only changing the Civil Service Commission, but also changing the city manager's duties to state that they have the city manager, when deemed necessary for the good of the city, suspend or remove all city employees, but then adding in now, subject to the Civil Service Commission power to hear and issue final binding decisions by the Civil Service Commission on grievances of terminations.
couple questions. Ralph, you said that we have collective bargaining right now? Is what you just stated?
Jonathan, do you want to clarify?
Yes, currently we have collective bargaining agreements with the International Association for Firefighters and Firefighters. So we do have, that's the only collective bargaining agreement we have.
You know, I guess my question, or my thoughts, I should say, is for the previous 3 or 4 years, the Civil Service Commission never met to do anything until just recently. This is the first time that they've met in probably 4 years, maybe 5, I don't know. It's been quite a while. They never had a meeting, not one, to work on anything. I feel that, the Civil Service Commission should go away altogether, personal opinion. Because, why all of a sudden are they popping up after 4 years of not doing anything? And since the city employees are not unionized anymore, that went away, why do we need a Civil Service Commission? I don't understand that. That's number one. Number two, to take away the city manager's authority to terminate somebody and he'd be overridden, why do we have a city manager?
I agree.
Why don't we just hire the Civil Service Commission to run the city? Because the city manager won't have any authority. So to me, the alternative 2 is just, that's a no-brainer from the get-go, period. you know, on the first, you know, if, on the first one, alternative one, you know, if the Civil Service Commission wants to get involved and give recommendations to the city manager or to the BOC, you know, that's fine. But don't go 4 years and not do crap, and all of a sudden, they're gonna jump up and say, hey, we wanna have the final say on everything. To me, it's just wrong. You know, it just totally is wrong. It just stinks.
Well, it also isn't right that for a group of, is it 5 people on that commission? Mm-hmm. 5 people. And they're not experts. They're not personnel experts. They, you know.
Yeah, not human resource experts, yes.
Right, exactly.
Right.
So I agree with John.
But it also says in here that the Civil Service Commission may be provided by ordinance passed by the Board of Commissioners for funding. I don't recall this ever coming to the board of funding the past one that's going on right now. So, yeah, what does that mean? Because the city's definitely funding that.
You know, when.
Nancy, where are you referring to that?
I was looking, I'm sorry,
Page 17.
it's D under ballot question 15,
Page 17.
page 17. Oh, sorry about the page number.
I think that refers to when we had a union and they have that, you know, that.
But it doesn't state in here for sure what it refers to. It just says, we pass by ordinance the funding and power of, and so, just saying.
I know when I was on the Civil Service Commission for 6 or 7 years, this was quite a long time ago, this was in the 90s, we did have I think it was just CWA, it was the union for some employees. And there was a need for it back then. I think that there was a need in a lot of, probably in all municipalities for civil service commissions, because they did kind of act as that catalyst between the union and whatever. But I think that with all of the regulations, with all of the federal regulations, the state regulations, and all of the different things that go on in our society today and our culture with regards to employees and what you can do and what you can't do. And I think that, and I know I've been in the city manager's office a couple of times when you get some directives about, you know, how you can treat, for instance, drug testing or something like that, okay? Just all different kinds of things that it becomes pretty clear to me that, as you said, Mayor, that the Civil Service Commission can certainly act as an advisory board, but really shouldn't have anything to do with grievances and stuff like that, because there's so much more that it involves now. I mean, we're not in the 90s and we're not in the 80s, and you can just say one wrong word, man, and you're just, that's just bad. So I have to agree that I think that as an advisory board, but I wonder if some future Board of Commissioners, decided also, if we didn't decide, okay, say we just let it slide and we, went on the way we're doing it, if maybe we wouldn't be helping some future Board of Commissioners to possibly tie in the wording of this ballot question of anything that we do with the Civil Service Commission in giving us the giving us the wording, okay, to say in the future that if the Civil Service Commission is disbanded, and then it wouldn't have to go, since it's in the charter right now, that there is that Civil Service Commission, if we wouldn't be doing a service to our citizens, and it wouldn't have to come back if we didn't do anything about it now, that we allowed something in this ballot question that could give, that would give anybody, I guess, the power to
Disband? Is
Yeah.
that what you're?
Right. Yeah, I don't know. I'm just suggesting that in 2 or 3 years down the road, it might become less of a, you know, a board that's required, or that's needed by the city.
You know, I was just kind of looking at the things that are crossed out on alternative one, you know, the personnel rules, the class. You know, have they done any of that in the last 5 or 6 years? And none to my knowledge. And from what I looked up, I could not find anything that they've done in regards to that. You know, so I'm just saying, you know, okay, if you want to keep them around as an advisory board, that's fine. But, you know, what have they really done? And are they willing to be active in the personnel rules or whatever, you know? You know, what is, if we keep them around, what is exactly going to be their
Their
Well, their chores. I mean,
Their
yeah,
charter, what
their
are they
tasks
going to do?
Yeah.
Right, because, yeah, and you're exactly right, John, because what I was just thinking of, and my words sometimes get garbled and sometimes I get confused, I know, but I know when I was on the Civil Service Board, it was just so important for us to help the city with job descriptions, really. You know, we did all that. We did studies. We did, I mean, and this was before we had computers, you know. We called all these different cities and tried to find apples to apples and helped in that regard. And now it's not being done that way. So, yeah, what is the purpose?
Madam Mayor.
Debbie, this is in there. It's in the old, it's been striked out, that they did do classifications of city positions.
Madam Mayor, if I may, this particular Civil Service Board has actually gone through the entire personnel manual for the city of Madeira Beach and has proffered some recommendations to the city manager and the HR practitioner to go through. And this particular board is obviously more active than previous board based on the information that I've been able to obtain. But I can tell you that personnel issues, compensation, classification, job description, there's so many other elements that touch federal and state law. It really is difficult for us to be able to educate and inform and provide the knowledge base to support them in a capacity where they can be entrenched in the personnel issues. From staff's perspective, I think there is some value to having that advisory board in certain capacities. But one of the things that, and the city attorney can provide more perspective on, as it relates to the grievance proceeding and how that is handled and the advisory committee and the advisory opinion, one of the things that we have to be mindful is if we go to a situation whereby you are having that grievance proceeding and you go through the different steps, you're also, in essence, providing your legal defense strategy in a public forum. So in the event that the ruling is not in favor of that aggrieved employee, you as a city have effectively communicated your legal strategy in the event that they decide to go to a circuit court. And so there's some things that you have to be mindful of. When we did some inquiries, most of the cities that we surveyed that are considered comparable cities do not have the Civil Service Board. Now, there was an analysis that was provided of entities that do have a Civil Service Board, but the entities that were provided are, I think the closest one was 38,000 all the way up to the city of Jacksonville that has well over close to 900,000 individuals and has 19 commissioners on their board. So the apples to apple comparison of the analysis that was provided was not something that I would utilize as a mechanism to compare. Now, you do have the authority right now to outline the duties and responsibilities by virtue of an ordinance of the Civil Service Board. And if you look at the language that's in the charter and the language that's in the code, that's some area for cleanup that I think the board needs to look at in subsequent meetings. And that's one of the things that we have on the agenda setting workshop to discuss with the board at your workshop in December. Some of the things, as staff is now reviewing the work of the Civil Service Board, and they've done some exceptional work. One of the things that we were able to discover is that ordinance number 837 that adopted the personnel rules and regulations was modified by resolution. You can't modify an ordinance by resolution, so our personnel manual has language that is not adopted by law, and then there's some language in that ordinance that conflicts with the charter. So there's a lot of work that still has to be done, and running that through a board just makes that process and a board that you would have to delegate a lot of financial resources. I think you have to provide them a labor attorney if they're going to have a lot of say in the personnel, and then you're going to have to dedicate, an HR practitioner to consistently meet with that board. So if it is the pleasure of the board to look at the duties and responsibilities, we can certainly bring that forward. But this board has reviewed the personnel manual, but there's probably at least a month's worth of work going through and finding out what conflicts with the charter, what conflicts with the resolutions. And we plan on bringing elements of that back. But to really drill down to the point is that civil service boards in their inception were consistent in a lot of agencies, was prevalent in a lot of agencies in the early 40s, 50s, 60s, and you saw agencies as they started hiring professional staff move away from that and disband those. In some larger entities that there is a lot of union shops and those types of things, that's where you see them prevalent. But in a lot of agencies, they're no longer active. But in the Code of Ordinances, you can outline the duties and responsibilities of the Civil Service Board.
So cutting to the chase on all that, I think that's what the committee, the review committee was trying to do, that you certainly have the alternative to do away with the Civil Service Commission. I felt, in my opinion, I thought that it was, by doing alternative one, was streamlining, modifying, reducing, because I didn't feel that as a layperson, we should be doing that. If I were a member of that committee, and I'm not, I'm just charter, but that's what we're paying the professionals for. This city is made up of various departments, including meeting the federal laws, meeting the state guidelines, having an HR person, having a qualified city manager who is staying on top of these things. And I think that why should we step back and expect those people to be educating a Civil Service Commission when they should be advisory but not policy making? And so it boils down to, do you revise it and allow it to be advisory? Do you do away with it, or do you give it more teeth? Those are your three alternatives.
I think we should table both of these for the moment and go back and look at what's in the code, what's in the charter. Well, the charter's here, but then in the personnel manual, and see where all the disconnects are, and then try to figure out what we do want this board to do. Because I don't think sitting up here and just reading this, I don't think any of us really know what capacity we want to keep them in.
That might be a good idea. And I don't mean to imply that whatever was good, what we did in the 90s should be done now, because definitely that's not the case. I mean, I would never think that, because it's a totally different time, okay? So I think that is totally, but I'm just saying that what was good then worked, but it definitely wouldn't work now. And just the fact that there are as many unknowns, or not unknowns, because you're finding all these knowns, okay? So that, we need to, maybe we do need to
But I think we
step
need
back on
not
it.
even do this in December's workshop. We need to push it off to January, February, because there's a lot of stuff we gotta look up on this and figure out. Because even though Jacksonville has a civil service board, I would like to see where they're going. I mean, the options are few and far between, but just seeing what other cities are doing with it that still have it, and whatever they're providing, do we really need it or don't we need it,
But how could we even compare them, Nancy, when they have
I'm just looking at
980,000 people?
I just want to look at their duties. I mean, I don't really know what other ones have ever done other than what it says right here in ours.
Will be better to compare it to some smaller cities.
No, I agree there, but even if we went back and looked up some older cities, or not older civil service boards from way back, and just see what their duties were, just to get some idea, because I really don't know.
But I think we can get rid of alternative two, totally.
Oh, yeah, definitely. I'm good with that.
And Madam Mayor, if it is the
I am too.
pleasure of the board to have, and we as staff believe that there needs to be a more comprehensive discussion with respect to some of the human resources policies that we have in place, as well as a discussion with the Civil Service Board. I think there's an opportunity to have a joint meeting to discuss their perspective and understand what they're looking at as far as their roles and responsibilities once you fill that board in its entirety. And then how do we create a pathway forward looking at the Code of Ordinances? Because you may be able to effectuate the change that you're looking for in the Code of Ordinances and then bring back something that modifies the language in the charter at a later date. But personnel is, and employment law is so, it's ever evolving, it's ever changing, and staff would just like the opportunity to have that discussion in greater detail and make sure the board is comfortable with some elements on the personnel side.
Okay. So we will table that one. Any discussion from the,
So we're gonna table 1 and alternative 2, we're just gonna say no on.
no?
Scratch, okay.
So basically then, that's 3, I think 3 or 4 of the 16 that we've either said no to or the table. So then that only leaves us 13 for the March ballot. So we have to decide if we want to do, we don't have to decide today, but we have to decide if we want to do all 13 in March, or if we want to do 10 or 7 or 6 or 8, or
Let's
whatever.
just do them
we
all,
want to
get it
do.
over with. Because we don't have the state and the county to
I
deal
understand.
with on that end,
Yeah,
so.
but I thought we were going to wait till the BOC meeting to make that, the next one, next week, Tuesday, to make that decision if we're going to, how many we're going to do. And that gives us a chance to kind of talk to some of our constituents and say, is this going to burn you out if we have 13 on there? Or should we only put 10 on there, or, and then,
I don't think you can ask the question until you get them drilled down and codified, because, if you're, I think you need to go to the first reading, have them in front of you, and then see how it
no, that's
filters
what I'm saying
out.
with the next meeting. Because, I'm just bringing up what the city manager said, that when his meeting today, those people were saying, well, this is too much. Is that kind of what they were saying?
Yeah.
So we need to kind of think about that. And that's next Tuesday, so it's not that far off, but a couple days to think about it.
One thing that was brought up at Monday's meeting, and Helen, to your point, where we were recommending that under 5.7, this A, merit principle, and for the life of me, I don't know why that was stricken. And I made the note on here that we did briefly discuss on Monday, well, why did we take it out? And I don't remember why. And Jonathan, I don't know, would there be any other principle other than merit that would be an evaluation tool on appointments and promotions? I just don't remember why we took it out.
And therein lies some of the challenge that we have, is because in the review, and not to get into great detail, because we'll do that at the workshop in December, is that the merit system that was adopted in the ordinance was modified by a resolution from all accounts, and that's one of the things that we're looking at. So realistically, from staff's perspective, the merit system still remains in place, even though it was modified by resolution, because it conflicts with the ordinance. So, and then, we have to look at the charter to see what the charter says specifically, and if it talks about a merit system, then that supersedes all of it. And those are some of the things that we're finding as we're peeling back layers of this onion to really try to find out what is the actual policy that we should be adhering to. From what I can see, and just my opinion and the research I've been able to do, is that the merit system seems to be in place. I'm trying to track down that resolution that modified it, but unless in that ordinance it allowed for it to be modified by resolution, the merit system still remains in place. And unfortunately, for whatever reason, we have not necessarily been adhering to the strict merit system. So therein lies the issue that we're going to have to bring you back an ordinance that adopts a lot of the changes and cleans up some things over the next couple of months. So I'd have to look at the policy and the ordinance and those types of things to be able to speak specifically, but I could not find something whereby it was modified by ordinance to get away from the mayor system. It looks like it was done by resolution. So it's still, it's supposed to be in place.
So the point being is that I'm not sure if that just was something that inadvertently was removed. I don't remember a specific discussion, but to the point of all of you with legal reviewing this, I think that it should be unstruck. And, you know, weighed out in the whole process against the ordinances and the policies and all of those other things, and may very well need to be left in. And Helen, thank you for pointing that out, because it was like, well, I don't know why we took it out, but
Well, I think all the struck and unstruck needs to be looked at against everything. And that's why I wanted to kind of table that so we could go
Yeah.
back and do that.
Yeah, so don't just take it at face value that it was removed, but all good dialogue.
Public comment?
Helen Palladino. Ballot question 15 was the one I really wanted to talk about, and there's no need to talk about it because I think you guys came to the exact right conclusion. Thank you. To the extent we have an HR person, I hope they're SHRM certified or on their way to become. Okay, perfect. And then we've got you. I think the city manager definitely needs the power to terminate employees and not 5 people that don't work with that employee. I think that's part of why you have him, just like we just mentioned. But best thing you can do with this one, I think, is get with your labor and employment attorney and rewrite your handbook. Don't do anything. Federal law and state law really covers a lot as far as how you govern HR, and HR is so important now. There's chief human resource officers in most corporations now. They've elevated it to that level. So, and this is all over America, so not that we're a business, but I mean, that's how important it's become, and it is such a touchy area, and you can mess up so easily. So I think the whole project of, hey, let's look at this totally separate head to toe is a great idea. And I think there's a lot you can get rid of. Thank you. And I wanted to say thank you again. I said this Monday night, but the Charter Committee, I'm very impressed with the way they've gone through this, our charter, and have tried to cull it down a little bit and make some sense of it and make it gender neutral and all the things that make it a more modern document. And I think we could probably take some stuff out and still clean it. I mean, I think it should be an ongoing process, frankly. We don't want to mess with something too much, probably, since we're on a pathway. But thank you for looking at it for the first time in, 20 years or so? You know, it's got to be, it's a lot to do, and there's been a lot of changes. So kudos to you guys for even coming up with all these different things to address. I appreciate it as a citizen that someone has done this. Okay, thank you.
Thank you. And we all appreciate everything that you've done, because that's a huge undertaking. And still is, continues. Any more thoughts, questions, comments?
I've combined 3 and 5, and listening to your comments, we have 12 items for your consideration for first reading. And I'll prepare the ordinance and the title with everything. And I'd recommend leaving the 2 alternatives in for first reading, just so you have the alternatives there, and then people can talk about it for 15. It should now be 12.
Okay. Meeting's adjourned at 8:24.